share that in common. And joining us later will be Vice Chair Congresswoman Shelley Pingree of Maine. Now, you're going to notice that David and I are here. We're ready to hear the testimony and get to work. Because of impacts of the shutdown and other things, many of our appropriations committees are just starting to get up, run, and organized right now. And so you're going to see people come in and out, and our offices have been in contact with them, and it doesn't reflect anything about their lack of interest in this. It's just that they're pulled many different directions this morning, so they'll be here lately. So we're going to be joined by some new folks on our side of the aisle, Congressman Mike Quigley of Illinois, Congresswoman Bonnie Watson-Coleman of New Jersey, Congresswoman Brenda Lawrence of Michigan. They're all new to the committee, but returning as Mr. Kilmer and Mr. Serrano. Mr. Kilmer's from Washington, Mr. Serrano from New York. So as we begin our work for the year, I think it's important that we just don't jump right in and focus on any particular agency or any particular program, but instead we start by reviewing our most fundamental right, which is Congress's power of the purse. The Constitution puts that power in the House and the Senate as members of the Appropriations Committee. And that means we're charged with taking the lead in safeguarding that authority for all of our colleagues. Ironically, the recent government shutdown has caused us to review the governing laws and the use of taxpayers' dollars, and to re-examine what is permissible and what is not. We've raised serious questions with the administration considering the authority of the executive branch to continue to operate various agencies and programs in the absence of appropriations, or to commingle appropriations between accounts. And unfortunately, we've gotten inadequate answers. The starkest example of questionable behavior is Acting Secretary Bernhardt's decision to direct Park Service to use federal lands and recreation enhancement fees revenues in place of funding this subcommittee appropriated had for operational activities. And I really have some very serious concerns about that decision, and so do members from the public. Those recreational fees are for capital improvement projects to enhance the visitor's experience. They're not a slush fund for the administration to use when it wants to circumvent Congress's power of the purse. So today, I hope we can begin to build a shared understanding of the underlying legal framework that surrounds our constitutional authority. For example, it's the Anti-Deficiencies Act, which dates back to the 1800s. One of the primary laws used to apply Congress's constitutional authority over public funds. The law prohibits the executive branch from spending federal tax dollars unless those dollars have been expressly appropriated by Congress. In addition, the so-called purpose statute dating from 1809 says money can only be used for specific purposes authorized by Congress. And finally, there are strict rules which require that if an appropriation is made for a particular program, then it is improper to use it for another appropriations operation. So to help us sort out through all these statutes and rules, and to better understand how funding lapses have been handled in the past, we will hear from three expert witnesses this morning. First, we're going to hear from Ms. Julie Matta. Ms. Matta is a Managing Associate General Counsel with the Government Accountability Office. She's one of GAO's leading experts on the Anti-Deficiency Act and various legal decisions concerning the Act. Well, Ms. Matta is not in the position this morning to give us an official GAO opinion on any specific agency action that occurred during the most recent shutdown. She will be able to help all of us collectively understand how these statutes have been interpreted in the past and the types of activities that are authorized and prohibited. Our second panel will hear from Sam Berger and Mr. Philip Francis. Mr. Berger is currently a senior advisor for the Center for American Progress. Between 2010 and 2015, Mr. Berger worked at the Office of Management and Budget as a senior counselor and policy advisor. He was involved in a variety of legal issues, including sequestration and executive orders. Most relevant today for us is Mr. Berger's involvement in planning, because there's supposed to be planning that takes place in case of a government shutdown, and the one he worked on was 2013. He will speak to how the decision-making process played out during that event, particularly from the perspective of the executive branch. And joining Mr. Berger is Mr. Philip Francis. Mr. Francis is currently the chair of the Coalition to Protect America's National Parks, which is the voice of retired Park Service officials. During his 40-year career, Mr. Francis served in numerous senior positions of authority, including assignments at Yosemite National Park, Great Smoky Mountains National Park, Blue Ridge Parkway, and Shenandoah National Park, and several regional offices. Mr. Francis is also the recipient of the Interior Department's Superior Service Award. As an experienced on-the-ground manager, we look forward to hearing to Mr. Francis's views on how to best operate and protect our national parks during lapse in appropriations. In addition to these witnesses, I would like to ask for unanimous consent to submit the testimony for the record from John Gardner of the National Parks and Conservation Association. Any objection?
I haven't had the ability to review it yet.
I'll let you review it, and we'll go right at the end.
Okay.
How's that? We have provided a copy of this testimony to each of you at your seats. So we'll catch it again and see if there's any objection to the testimony being submitted. Before I turn to our ranking member for his opening remarks, I'd like to take a moment to cover the hearing logistics. Ms. Matta will give her testimony, and then we will conclude with 2 rounds of questions and answers. After panel 1's questions are completed, Ms. Matta will be excused, and we will call up our second panel for their testimony, and each member will have 5 minutes for a round of questions. And there's one other thing. Some of you know I'm a former teacher, so I have a glossary. Because words are important, definitions are important. And so I wanted us all to have the same set of definitions that are from statute and rule as to what accepted employees are, exempted employees, offsetting accounts. And so with that, Mr. Joyce, I know you know accounts well. I will turn over to you for any opening comments you'd like to make.
Well, thank you. Thank you, Chairwoman McCullum. It's an honor to be serving with you in this capacity on the Interior and Environment Subcommittee. I look forward to many years of bipartisan work on so many important programs within the subcommittee's jurisdiction. We may not always agree, but I have full faith that when we disagree, it'll always be in a respectful manner, and it will never get in the way of the work we need to accomplish on behalf of the American people. Our constituents deserve nothing less. Today's hearing comes on the heels of the longest partial government shutdown in U.S. history. Sadly, hundreds of thousands of people suffered real-world consequences because of the shutdown, and we know that our nation will be recovering from the impact for quite some time. While we may not agree on the size of the federal government, I think the impact of the partial shutdown makes it clear that we need the federal government in order to ensure vital services and resources to make it to our communities. That is why the government strives to exercise its full authority under the law to minimize the disruptions of people's lives in the event of a lapse in regular appropriations or shutdown. We all know that the Constitution assigns the power of the purse to the Congress. It is incumbent upon Congress to exercise that power through laws that can be easily interpreted and faithfully executed by the executive. But as the courts demonstrate every day, Congress isn't always clear on what it wants and what it doesn't want. So if Congress disagrees with the way the laws are interpreted and executed, then it is incumbent upon Congress to change or clarify the laws. The laws for operating during a lapse in regular appropriations are complex and frequently misunderstood. And I look forward to understanding them better from the help of our first panelist, Julie Matta, from the GAO. But the question of whether agencies under this subcommittee's jurisdiction fully complied with these laws is not one that can be answered in this hearing today because none of us here have all the information needed to answer it. Moreover, disagreements we may have today about the agency's actions taken during the shutdown may not be about legality, but about interpretation and therefore about policy. It's often said in policy making there's no right answers, only choices. Do I agree with some of the choices made by the National Park Service early on in this shutdown to keep the parks open without providing basic sanitation services? No. On the flip side, though, I did agree with the choice made by the National Park Service during the shutdown in 2013. Did I agree with the choice made by the National Park Service during the shutdown in 2013 to try to barricade the World War II veterans from visiting their memorial on the National Mall? Absolutely not. Both choices made under different administrations may have been technically legal uses of appropriated funds, and both choices illustrated the need for us to work together to find reasonable middle ground. So while I look forward to the testimonies and the thoughtful discussion ahead of us today, I also look forward to the opportunities in future hearings to have similar discussions with the Acting Secretary of the Interior, the Acting Administrator of the EPA, and others. And while we have healthy debates on policy, let us all agree that it is in no one's best interest to shut down our government ever again. I yield back.
Thank you. We have an opportunity if Mr. Kilmer, if you'd like to make opening remarks, or Mr. Simpson would like to make opening remarks. Mr. Kilmer? Okay, then we'll move right into it. Ms. Matta, as you know, one of Congress, excuse me, as you know, we're here to learn and listen from you, and everybody has a copy of the testimony to follow along, and so I'm turning it over to you.
Good morning, Chair McCollum, Ranking Member Joyce, and members of the subcommittee. Thank you for inviting me here today to speak about the legal framework that informs Congress's oversight of agency operations during a lapse in appropriations. As no one in this committee needs reminding, the Constitution grants Congress the power of the purse. It makes clear that no money may be drawn from the Treasury, but in consequence of appropriations made by law. And it is in those appropriations, whether provided through the annual process or in permanent law, that Congress guides federal agency activity by prescribing their availability with regard to purpose, amount, and time. The cornerstone of this statutory framework is the Anti-Deficiency Act. The Act very simply tells agencies that they can't spend more than Congress has given them or spend it before they get it. Additionally, the Anti-Deficiency Act prevents agencies from allowing its employees to volunteer their time during a shutdown. It's this voluntary services prohibition that sends many federal employees home during a shutdown. It has become a topic of late in part because it contains an exception for those employees who protect life and property from imminent harm. Appropriation lapses implicate the Anti-Deficiency Act. When an agency does not have a currently available appropriation, whether a full-year appropriation or a continuing resolution, and it does not have other statutory authority to operate, it must cease operations by virtue of the Anti-Deficiency Act. This is what caused several agencies to shut down at midnight on December 21st. Conversely, the enactment of the continuing resolution on January 25th allowed the affected agencies to fully reopen. However, some agency operations did continue during the interim period. Based on Department of Justice issued guidance to executive branch agencies in 1980, 81, and 95, as well as GAO opinions on the Anti-Deficiency Act, agencies may continue to incur obligations in the absence of necessary budget authority and not violate the Anti-Deficiency Act where those activities fall into certain exceptions. Activities to engage in the orderly shutdown itself, activities to protect life and property from imminent harm, activities to carry out core constitutional functions of our government. Additionally, in 1981, the Attorney General noted an exception to process Social Security payments. The Attorney General opined that agencies may carry out certain duties during a lapse if the authority to do so arises by the necessary implication from the agency's authorities. In a footnote, the Attorney General explained that it was under this necessary implication basis that he authorized obligations in order to process payments for entitlement programs. The funding for the benefits themselves for these entitlement programs is available because it comes from an appropriation like the Social Security Trust Fund that is available outside of the annual appropriations process. While GAO has never raised any objection to the processing of Social Security payments, an expanded reliance on a necessary implication theory in broader contexts than entitlement payments could raise significant concerns for Congress's constitutional powers during a shutdown. GAO's appropriations lawyers are available to you and your staff to provide informal technical assistance regarding the application of the Act based on our prior work. Our informal assistance serves to help identify possible issues, but it does not provide Congress with GAO's legal opinion. For example, there have been many media reports about the Park Service's use of entrance fees to operate certain parks during the shutdown. While I am unable today to speak to the specifics of what the parks did, I am able to identify certain legal questions that might arise from the use of those fees, such as an appropriations law concept known as the pick and stick rule, which provides that agencies can't switch appropriations simply because one account has run out of money. GAO only speaks officially on matters of appropriations law through the issuance of our published legal opinions, which stem from the statutory responsibilities that Congress has vested with the Comptroller General. As with all of GAO's work, our legal opinions provide Congress with information that is objective, nonpartisan, and non-ideological. Should you, Chair McCollum, Ranking Member Joyce, or members of the subcommittee seek GAO's legal opinion on particular agency operations during the most recent lapse in appropriations, we would be happy to take your request and follow our protocols to issue you our legal opinion. I am happy to answer any questions you may have. Thank you again for this opportunity. This concludes my prepared statement.
Thank you. So it's very clear that the Anti-Deficiency Act, as you know, exists to protect constitutional power. And part of the reason why we're having the hearing today is because I'm concerned about potential violations that may have occurred during the shutdown when the executive branch had agencies to continue to operate without the funds to do so. So I'm going to put a couple of questions together and then let you figure out the best sequence in which to answer them. What does the Government Accountability Office do? What is it exactly that you do? As you mentioned, you can issue legal opinions to help us to make sure that the agencies are complying with the Anti-Deficiency Act. And so could you explain a little more in detail what the Anti-Deficiency Act prohibits and what can happen when an agency violates that act? And what does limit the Anti-Deficiency Act place on agencies when they don't have the funds to operate? So there's limits placed on them. And then finally, what does an agency able to carry out, if anything, when funds are not available? So you touched on that a little bit, but I'd like you to expand on it a little more with the questions.
Yes. Okay. The Anti-Deficiency Act is at its heart a funds control statute. Congress began enacting it back in the 19th century. It's been enacted in pieces over the years, really as Congress has been reacting to agency behavior and in an attempt to sort of protect Congress's constitutional power of the purse. Essentially, the Anti-Deficiency Act has three prohibitions. It tells agencies don't spend more than Congress has given you, don't spend it before you get it. It tells agencies you can't accept voluntary services, a slightly technical term. I can go into more detail if necessary. And then it also tells agencies you can't spend more than has been apportioned or allotted, some more technical budget terms, but essentially setting up a system of funds control for agencies, protecting that very, arguably one of the most important constitutional powers that Congress has, that power of the purse. Agencies cannot operate unless Congress has provided them the funding to do so. Consequences of violating the Appropriations Act, it's the only appropriations law statute that contains both civil and criminal penalties for its violation. The administrative penalties that have fallen to federal employees that have violated it have ranged from dismissal to demotion, letters of reprimand, remedial training, and the like. GAO is only aware of 2 employees ever being dismissed. As far as we are aware, there has never been a criminal prosecution of the act, but it is certainly those potential criminal penalties that make the Anti-Deficiency Act one of the appropriations laws that almost all federal employees have heard of. Importantly, the act requires agencies that have violated the act to report that violation to the president, the director of OMB, and to the Congress. In 2004, the act was amended to require that such a report also be provided to the Comptroller General. GAO thus serves as a repository of the Anti-Deficiency Act reports for Congress, and we have those going back to fiscal year 2005. If there is a lapse in appropriations, a funding gap, and agencies don't have an appropriation or another source of budget authority to operate, then they are required to close down their operations. And the legal framework that GAO uses to assess what an agency has done during a shutdown really can be netted out as follows. The first question we're always going to be asking is there an available appropriation? So thinking back to that purpose, amount, and time construct that sort of governs all appropriations law questions, is there an appropriation available for that purpose? For example, does the agency have some sort of permanent budget authority, like contract authority? Department of Defense has some notable exceptions in the Feed and Forage Act that allow it to incur obligations in advance of an appropriation. So we'd be looking for something that specific. Does the agency have an appropriation? Those purpose questions bring up other issues that I can go into more detail on if necessary. If the agency does not have an appropriation, then the Anti-Deficiency Act is implicated. And so then we start to talk about what are those exceptions to the Anti-Deficiency Act that are most relevant during a government shutdown as the agency is evaluating what to shut down and what it would keep going. The most well-known exception is embedded in that voluntary services prohibition, that second thing the agencies are not allowed to do under the ADA except voluntary services. It says, except to protect life and property from imminent harm. So sort of that emergency exception, protect life and property from imminent harm. Notably, in 1990, the act was amended and additional language was added to that emergency exception saying this does not include the routine ongoing operations of government. So Congress speaking in 1990 to clarify some what it means by that exception of to protect life and property from imminent harm.
Ms. Matta, I'm
Yeah.
going to give you another minute.
Oh, I'm sorry.
I want you to worry about this.
Okay.
We have another minute. We want to hear what you have to say.
I apologize. Additionally, based on those DOJ opinions and GAO opinions on Anti-Deficiency Act, the other categories of exceptions would be carrying out core constitutional functions. We don't want the republic to fail because everyone goes home. Agencies need to incur obligations for people to actually engage in an orderly shutdown. And then, as I mentioned, that necessary implication exception that has been applied, as far as I'm aware, to the Social Security program. I do not think I got yet to GAO's role under the ADA. Would you like me to touch on that?
Is that with Mr. Joyce? I think we want, that's why we brought it here, so we're going. So, yes, please.
Okay.
Take another minute or two.
Very quickly, GAO's role with regard to the ADA. The Comptroller General is statutorily directed to issue legal opinions at Congress's request. Although I would note that the GAO does not have enforcement authority related to the Anti-Deficiency Act. Congress uses those legal opinions to conduct its oversight and to protect its constitutional purse strings. Our legal opinions are addressed in our 3-volume treatise on all things appropriations law. It's known as the Red Book, used across the government, cited as authoritative sources by agency attorneys, inspector generals, and the courts, including the Supreme Court. And additionally, we are the repository for those ADA reports.
Thank you.
You're welcome.
Thank you very much. Mr. Joyce?
Thank you. Because I know that some members need to move on. Thank you for your explanations here today, and thank you for attending. You mentioned before, could you explain how the pick and stick rule you mentioned in your testimony might apply to the use of funds collected under the Federal Lands Recreation Enhancement Act?
Yes, Ranking Member Joyce, I can explain what the pick and stick rule is and sort of how that issue arises in this situation. The pick and stick rule originating from the purpose statute, as Chair McCollum mentioned, it's 31 U.S.C. 1301, enacted back in 1809, so around for a long time, tells agencies simply you can only use appropriations for the purposes for which Congress has given them to you. Given the breadth of the federal government, Congress is not appropriating dollars for every single line item. And there do arise situations where arguably an agency has more than one appropriation available for the same purpose. In those situations, what our case law has said is that agencies need to pick and stick with that same appropriation, and that they can only change if they notify Congress through the regular appropriations process, thus providing Congress the ability to provide oversight over how the agency is using those taxpayer dollars. And essentially, the pick and stick rule helps provide for consistency and reliability in Congress's knowledge of how an agency is using its appropriation. So in the fees situation, if looking at it through the appropriations law lens, we'd be looking at, what are the purposes that Park Service's general operating appropriations were made for? What are the statutory purposes for the fees? Is there overlap? Has the agency elected one appropriation over the other? And thus, should it be required to adhere to that? And so that's sort of the pick and stick rule in the fees context.
In 2006, the GAO reported on agency use of recreation fee funds and noted many sites use these funds for daily maintenance and operations, including restrooms. The report made no mention of any concern as to how funds were used, nor did it mention the pick and stick rule. Why the inconsistency in GAO's interpretation between the 2006 report and today's testimony?
I would have to look at that 2006 report. I'm not familiar with it. I apologize. But I can certainly look at that and provide you an answer for the record.
Fair enough. You know, in his opinion of GAO that any agencies under the subcommittee's jurisdiction violated the Anti-Deficiency Act or any other statutes during this recent lapse in appropriation?
We have not issued any legal opinions or reached any conclusions about agency operations during this shutdown, and we would only do so if we were asked by Congress.
If the GAO were to form a legal opinion on this matter, is it possible GAO would conclude there's no statutes that have been violated?
Absolutely, it's possible.
Great. I have no further questions.
Mr. Kilmer?
Thanks, and thanks for being with us. I represent an area that has 11 federally recognized tribes, and heard, I think, from every single one of them over the course of this last shutdown around the impact of the shutdown on them. I know in your testimony you said that the federal agencies can continue unfunded activities if they're necessary to protect life and property. I'm wondering, has the GAO or have the courts looked at commitments made through treaties, and whether those would fall under the president's constitutional obligations or anything else, in that, certainly in the views of the tribes, and in my view, these are commitments that have been made from our government. These are trust responsibilities and treaty obligations, and during the shutdown, they aren't met.
Representative Kilmer, I'm not aware that we've ever issued an appropriations law opinion addressing treaty obligations, but I will certainly go back and double check and also provide you that for the record if we have.
Thank you. Thanks. That's what I got.
Thank you, and congratulations on assuming the chair of the Interior Appropriations Committee. I look forward to working with you and
Thank you. It's a
my
great
colleagues.
committee,
I
both
see you
sides.
flip sides on us, and it's so confusing for me. You know, I'm just an old guy.
Well, we picked up a little more staff, so we needed a little more space.
Yeah, I get that. Appreciate your testimony. Anti-Deficiency Act. You mentioned 3 different exemptions. One of them was core constitutional responsibilities. Define core constitutional responsibilities as opposed to any other responsibilities we have.
So core constitutional responsibilities addressed in an 81 Attorney General opinion, also addressed in a 1990 letter that GAO wrote, essentially focusing on those constitutional powers of the other branches. We would not be interpreting the Anti-Deficiency Act in a way that would allow one of Congress's checks or Congress's powers to impact the core powers of the other branches. So very practically speaking, the Anti-Deficiency Act, if Congress were to experience a lapse in appropriations, the Anti-Deficiency Act would certainly not affect Congress's ability to keep operating in order to enact those appropriations acts to bring everything back online. The Anti-Deficiency Act does not affect the president's ability, the executive's ability to carry out, those duties that are outlined in Article 2. So think about the appointment power, think about pardons, that sort of thing. So the constitutional power is sort of laid out. It would not expand or stretch to sort of anyone across the government. It really would be those people carrying, very closely carrying out the Constitution.
Not those things we're supposed to do. You mentioned that one of the exemptions was life and property.
Yes, sir.
Is sanitation a health issue?
Yes, sanitation is a health issue.
Could have the parks gone in and taken care of the sanitation in the parks that was getting left alone and so forth on the basis of a health issue?
That is an excellent question, Representative Simpson.
That's why I asked it.
Yes, yes, absolutely. And it's certainly one of the things that if GAO were asked to examine this issue that we would be looking at. Obviously, the context and the facts matter, and a thoughtful application of the law to those facts is what results in a legal opinion that you all can use.
When you say health and property, could have the Park Service maintained personnel at Joshua Tree National Park to prevent the damage to property that occurred there?
Again, that would be one of the questions. So when we think about the exceptions to the ADA and that protection of life and property from imminent harm, that is a question we would be asking, or a lens we would be looking through.
Okay, appreciate that. I guess the compromise solution that we're all seeking here is don't shut the damn government down. And these questions wouldn't be necessary. So I appreciate you being here today. Thank you.
Thank you. Mr. Amity?
Thank you, Madam Chair. And I'd like, for the first time probably ever, align myself with the comments of my colleague from the state of Idaho. I'd like to change my comments. I'm shocked. Actually, I kind of like the view from over here better, and I do want to also let you know that instead of drinking out of plastic and stuff like this, that I'm feeling a little bit more snooty now that we're drinking out of glasses like the people that fly in first class. I appreciate that. It's nice to have a new sheriff in town. How you doing?
I'm well, sir.
So I think based on what I've heard, and I apologize for missing some of it, but my perspective is kind of similar. When you talk about a federal government shutdown and you represent a state where the red part is owned by the federal government and 2/3 of that red in Nevada is owned by one federal agency, and that federal agency at the beginning of the shutdown basically says none of our personnel are key. These are my words, nobody else's. None of our personnel are key, but if you know the acting state director's cell phone number, you can call him. And I'm going, wow, because we sit here on this committee and we talk about important things and the federal estate and how important it is, and then in this context where you say the agency itself, some people would argue, values its mission in the state at, and I'll let you finish the sentence however you want, it's kind of nuts. I would also note at the same time that the Forest Service at least had district rangers employed, and in Nevada we have one combined federal national forest. So the forest director and that person's district rangers were at least on duty. And you say, well, the law enforcement and the fire people were on call. It's like, that's great. But basically, to have nobody on duty, and I look at these exemptions and say, and you said the word context, which I think that's kind of the short and tall of it. So I guess I will, have we requested an opinion from GAO on these exemptions? And let me tell you why I'm asking. It's something that quite frankly I think needs to be done, and so I'm not going to say if the committee doesn't do it, shame on whatever, but we want to work with your office, and I'm with Mr. Simpson. It's like, hey, I hope this doesn't happen again. I mean, I haven't been around forever, but I think it's pretty clear that no matter who gets blamed or whatever, nothing changed from before to after in any of them. Not for healthcare, not for DACA, not for whatever the last one was about. So it's like, if that's going to be part of the landscape, then this bit where you're basically the owner of a state and you shut down makes no sense to me, because I think somebody, or when you look at the context, are key people. So have we asked for, Madam Chair, is that a secret question that I should withdraw? Because I'll withdraw it if I'm supposed
It's not a secret question. That's why we're having the hearing.
Uh,
to. Okay.
And we're having the hearing in the spirit of really understanding what they did, why they did they follow plans, and if they did follow plans, do they align with our constitutional responsibility of having the power of the purse, or was it a way to go around us making exceptions? So that is, I think GAO's taking a lot of questions, and Mr. Kilmer had great ones on treaty. You've got one on BLM. I've got some other we're going to put in, and we need to, first, I agree with everyone. We shouldn't be shutting down the government. Couldn't agree with that more. But there is a process and ways and rules and regulations in which, when this does happen, that there's expectations that things will be followed. So we will do that.
Okay.
So which kind of leads in, are you done?
So we'll be in contact with you in that context. I appreciate you coming in. I yield back, Madam
Well, thank you, thank you. So I want to kind of ask a general question. Mr. Simpson and I and many of us have, the question, when does something become a threat for public health or sanitation? But there also goes to the question of what is life and protection of property, and what is proper to have open during the shutdown, what are the absolutely essential government services versus what are not essential government services. So if it's not essential, that for example, if the decision is that it's not essential that the national parks be open, and I don't think it was essential that the national parks be open, although it pained me that they were closed because we had a shutdown, does that fall into the category of health and property? So that is something that you can take a look at because there's case law and other opinions that will help you inform that decision. Is that not correct?
Yes, that is correct, Chair McCollum. And as with any legal opinions that we would do, and I'll go back to that word context, a thoughtful, careful application of the Anti-Deficiency Act, the exception to the facts at issue is necessary in order for us to give you an opinion on which you can rely.
So Mr. Joyce and I will be asked at times to sign off with transferring of funds, which kind of goes back to the pick and stick. So, and in notifying Congress, and you and I'll get asked to do that once in a while. We confer, and almost, I think, 100% of the time it happens. There's rare occasions where, you and I will have serious questions and we'll want more information. So having said that, the department chose to open up, the Parks Department chose to open up, and then they chose to use park entrance fees, which are contained in a separate funding account because the basic operating appropriation was not available. And you mentioned that Congress is supposed to be consulted if somebody's looking at doing significant transfer of funds. And I didn't hear from Secretary Bernhardt, we didn't hear from Secretary Bernhardt until after I submitted a letter requesting, what are you doing? Can you explain to me why you've decided to use these fees? And he sent me a letter basically defending his decision for using those fees, and then he used a more general entrance fee statute, which Mr. Simpson mentioned earlier, for his use of using the Federal Lands and Recreation Fee Act. So, he completely ignored the requirements, at least in his notifying Congress, letting Mr. Joyce and I know that he was going to not pick and stick to what he did with the Park Service operations account funding. So the service is not legally able to just switch different accounts during a shutdown. So could you please explain a little more of your written testimony, the origins of pick and stick use? It comes from very specific statutory language, does it not?
It derives from the purpose statute, ma'am, correct.
And why were there were reasons. There's always a reason behind a rule. We might not agree with the rule, we might not agree with the reason, but there's always a reason behind the rule. What is that rule? What is that statute trying to control?
So the origins of the pick and sticks rule, again, deriving from the purpose statute, again, sort of hearkening back to Congress's exercise of its purse power and oversight of agency spending decisions. And the idea behind the pick and stick rule, again, is that given the depth of the federal government, the breadth of the operations, Congress isn't appropriating down to every single line item that an agency may do. And so where you have an agency with multiple appropriation accounts, and one could argue that any of a number of appropriation accounts are available for a particular purpose, we want agencies to pick and stick with the same one to provide Congress with reliable, predictable information and expectations for agency behavior, because that is how you are able to appropriate in a way that you can rely on how they're going to use the funds, and that's going to be how you exercise your purse strings and your oversight. So really the origin, sort of going back again to this idea that the power of the purse is the legislative branch. It belongs to Congress.
Mr. Joyce, another follow-up?
Not necessarily as much follow-up as sort of a clarification for all of us if we were to engage Ms. Matta in a request for an opinion, that we would need, she talked about being in context, we would need to narrow the set of facts. So she's only going to answer the question she's asked. So I think as a committee, we would need to define what it is we're going to ask her so she can deliver an enlightened opinion on these things. And part of the problem, I think And I would just like to clarify, I understand we're not going line by line in appropriations, but for purposes of illustration, say we give $1 million to an agency and they have 10 different accounts, and so they put 100,000 in each account, and they declare that this is a dire emergency, that things are being vandalized in the park. If they were to shift $100,000 from stationary and, office expenses to law enforcement, was that what you're saying is not allowed by the pick and stick rule?
Ranking Member Joyce, the pick and stick rule would apply if Congress has actually appropriated two separate appropriations. My understanding of your question, I would describe what you just mentioned as a concept we call reprogramming, where within one singular appropriation account, the agency is moving money between different line items. Mm-hmm. Agencies have inherent authority to reprogram within one appropriation account. Of course, Congress can put all sorts of restrictions on that. So if we were looking at agency spending decisions within one account, it would be in that context of what is a reprogramming for purposes of how your committee has set up the appropriation for the agency in question, any notification requirements you may have you incorporated additional restrictions by reference to committee reports or conference reports. The pick and stick rule is really about purposes in two different appropriation accounts, which is why it harkens back to that purpose statute. The ability to move funds between appropriation accounts we refer to as transfer, and agencies must have affirmative statutory authority to do that. They don't have any inherent authority to transfer.
So to take that one step further, again with the $1 million and the 100,000 in
Sure.
each line item, but there's also a self-created or a legally formed entity like Parks Recreation fees that is outside of this $1 million, right? And so they're generating these fees. Say they generate around $100,000 in fees. They have the discretion to use those fees as they see fit to take care of things like an emergency sanitation, safety, health, safety, welfare of the people visiting the park or people working at the park, correct?
So that would be the question we would be asked.
Right.
That would be what we would be looking at if we were asked, is what does the authority for those recreation fees say? And we would be analyzing it in the context of all of the statutory authorities that Interior has and how the appropriations have been enacted. So that is exactly what we'd be looking at. We have a couple legal opinions where Congress has expressly allowed agencies to bounce back and forth between two appropriation accounts. We look for that sort of express authority, again, because our lens is always protection of the purse strings.
In that light, in this last situation, from what you're saying, GAO was never asked that specific question, that the policies were just put in place to secure the area in a shutdown or an emergency circumstance.
Yeah, we have not yet been asked any questions about it.
Thank you.
And Mr. Joyce, that was to my comment earlier, we'll be asked to reprogram funds, which is, at times can be very routine.
Sure.
We were not asked about transfer of funds, which is even a higher level. We were not part of that conversation, even though I had spoken with Acting Secretary Bernhardt just a couple days before the decision was made. And so I think that's the heart of what we need to figure out. If we have to be consulted on rather routine programming, not to be consulted on a transfer, I think was an error and something which we need to say is not acceptable to whether anyone in Congress on the Appropriations Committee making those decisions. So I agree, we need to get to the bottom of it. Mr. Kilmer?
Sure, and you just mentioned the sort of activities funded from two separate appropriations. In your testimony, you mentioned a September 5th, 06 letter from the GAO to the Homeland Security Subcommittee, in which GAO references activities being funded through two separate appropriations. And in that letter, GAO explains that if there are two appropriations, one with a general purpose and one with a specific purpose, that the agency must use the specific appropriation to pay for that activity. So I was hoping you could expand on that and explain the difference between
Sure.
a general appropriation and one that is more specific.
Yes. So Representative Kilmer, in the purpose context, we are essentially going through a three-part analysis if a purpose question is put before us. The first question, where an agency has multiple appropriation accounts, is going to be, is there one appropriation account that is more specifically available for the expense in question? This sort of lines up with statutory construction concepts that we use. And so if there is an appropriation that is more specifically available, that is the appropriation account that the agency is required to use. Pick and stick would arise if arguably there is not one that is more specifically available. If you could argue basically that both are reasonably and logically related to the expense in question, then we go to pick and stick. But if there is an account that is more specifically available, the agencies must use that more specific account.
Okay. I think that covers it for me. Thanks.
Mr. Simpson?
First, I just want to say, this 2006 GAO report, I would hope you would review that and get some consistency, because I can see an agency looking at that and saying, geez, you know, we use 25% of our rec fees for the following season's operations, and that was brought up before GAO, and they never talked about pick and stick then. So why wouldn't it be okay now? I can see them drawing that conclusion from that. So I hope you'd review that 2006 ruling and see if we can get some consistency for them to follow. Secondly, there's also an exemption, and I don't even know if you'd call it an exemption, but multiple year appropriations. They can continue on those multiple year appropriations even during the shutdown, correct?
Yes, that is absolutely correct, Representative Simpson. And that would be sort of in that first question of the legal lens we'd be applying. Does the agency have an available appropriation? And they most definitely have an appropriation available. If there is a multi-year appropriation account or a no-year appropriation account that goes beyond the end of that particular fiscal year. And so we'd be looking at, is that the agency's normal appropriation that it uses for this expense? And Congress would have lessened the purse strings, held them a little less tightly by allowing the agency to have that multi-year appropriation account. So yes, that would be anchored in that very first question we would ask.
Okay, thank you.
You're welcome.
Thank you, Madam Chair.
Yes, Ms. Pingree passes, so I'd be happy to go to you, Mr. Amade.
Well, actually, we talked, and she needed a little more time to have her questions be even more of a rifle shot, and so I'm happy to help Ms. Pingree whenever she wants. Thank you, Madam Chair and Madam Vice Chair. So if I was going to go back and forensically, for instance, say, okay, so I want to see what happened with this agency in the shutdown in my neck of the woods for general operations, then I gather from the discussion here, it's like, well, you want to see if, you want to know about anti-deficiency, you want to know if there's multi-year or no-year stuff to do, you know, just keep the lights on, not, hey, keep charging hard and all that other sort of stuff. Can we get a hold of somebody in your office, just say, so what do I want to look at when I go forensically through what actually happened in this, whereby people were kept on duty or not kept on duty in some sort of a skeleton sense or no sense? So your office could be of assistance in terms of, if you're not going to spend money, then as a general proposition, it's because you didn't have any multi-year that you could have used for it, you didn't have an exemption from the Anti-Deficiency Act, and you didn't have no-year appropriations, among other things. Correct?
Yes, sir, and we'd be happy to walk you or your staff through those questions that we would be asking.
And then the last part of my question is this: is there any guideline that says, you as an agency in a shutdown, this is who makes, because quite frankly, from a forensic standpoint, it's like, well, I want to know who made the decisions with respect to this particular instance. And I think there's some other folks here too, obviously different than mine, but it's like, so who made the decision that nobody was key in this particular area? Is there anything that you're aware of in the applicable statutes that say that decision will be made either by the council, by the secretary, by the bureau director, by the whoever, or is it just kind of each agency sort of does what they think, but make no mistake, somebody's responsible for saying, I'm the one who advised the secretary, or I did that as the secretary? What's your understanding of how that works?
So as a general observation, sir, I will note that the Office of Management and Budget, in its circular governing agency budget behaviors, tells them to have what they refer to as a contingency plan for shutdowns. I would expect that contingency plan would lay out some of the answers to the questions you're asking. I do not know for sure, though, but that would be where I would first go is sort of to that agency plan to see what it says.
Okay, so the first question would be, hey, OMB, let me see what Interior's plan is.
Correct, sir.
That's interesting, because I talked to OMB, and I'll just yield back and thank the chair and the vice chair for their professional courtesy. Thank you.
I'm sure OMB is thrilled to know you're doing that. So I want to thank you so much. And one thing that I came across in a Post article is the fact that we have an acting secretary, which is just the way Mr. Bernhardt's title is right now. I know he's looking to maybe be a full secretary. That there's even some discussion within some of the agencies that advise legal opinions as to, does an acting secretary have as much authority as the secretary? Is that something that would be part of your report, or should we direct that to someone else?
It would not be part of an appropriation law opinion, ma'am. GAO does carry out certain reporting functions under the Federal Vacancies Reform Act of 1998. We'd be happy to provide your staff with more detail on that for the record or after the hearing.
Well, I want to thank you and GAO so much. As you can see, we have more questions. We're just trying to understand what happened, why it happened, and if there was any go around Congress, because if we don't stand up as legislators and stand up to the executive branch, we're not fulfilling our constitutional duty. And I think that that's something that we all share here, no matter who the administration was headed by. So thank you very much for being here today.
Thank you, everyone.
Good. Then we'll do it before you come.
I'd like to invite our panel, second panel, to the witness table, please. And we're going to start with Mr. Berger's testimony, and then Mr. Joyce. What I'd like to do is have the questions directed to Mr. Berger for a while, and then go to Mr. Francis, if that's okay, unless you'd like to take both testimonies together. I'm trying to give you choices here. Something kind of different.
I'm glad to default to whatever you think is appropriate.
Well, then I think we'll hear both together. So Mr. Francis, and then we will hear from you after we hear from Mr. Berger. Thank you.
Chair McCollum, Ranking Member Joyce, members of the subcommittee, thank you for allowing me to testify today on how the Trump administration managed this shutdown. The Trump administration's handling of the recent funding lapse was characterized by unusually significant changes to agencies' established plans during the shutdown, with seemingly little regard for legal constraints or programmatic considerations. We saw this at IRS, where tens of thousands of employees were illegally recalled to work to process tax refund payments. At the Bureau of Land Management, where employees were brought back in order to approve oil drilling permits. At OMB, which drafted guidance that would have resulted in illegally executed payments to contractors and grantees. And at our national parks, which reversed precedent to remain open with a skeleton staff, predictably endangering parks and visitors, and then altering course again when the predictable occurred. Based on my own experience planning for and implementing a shutdown, the current administration's approach raises serious concerns. I served as an attorney in the White House Office of Management and Budget from 2010 to 2015. While there, I was involved in the planning process for potential shutdowns and part of the senior team providing government-wide guidance during the 2013 shutdown. Contingency planning for a shutdown is a time-consuming and involved process. Simply put, the government is not designed to shut down, and determining what shuts down and how is complicated. Since the Constitution gives Congress the power of the purse, there are legal limitations on what executive branch officials can and cannot do in the absence of enacted appropriations. As set forth in DOJ opinions that go back 40 years, essentially only 3 types of unfunded activities can continue during a shutdown. Those necessary to protect life and property, those necessary to discharge the President's constitutional duties and powers, and those authorized to continue during a lapse in appropriations, either expressly or through necessary implication. Determining what does and does not continue during a shutdown takes time. Each agency works closely with its Office of General Counsel to ensure they've carefully thought through how they will operate during a shutdown consistent with applicable law. This includes how an agency plans to utilize any potentially available funding, and how the operations may change over the course of an extended shutdown in response to predictable circumstances. Unless agencies are working off a relatively up-to-date plan, the drafting of a new shutdown plan can take weeks. While there is recognition that plans may have to be altered due to unforeseen events, developing and publishing the plans ensures a measure of predictability and agency accountability to relevant stakeholders, Congress, and the public. Minor changes to operating plans are expected during the course of a shutdown, but the Trump administration repeatedly made significant changes. Given that agencies are supposed to plan in advance for knowable issues, this pattern raises serious questions. Were the agencies negligent in planning for the shutdown? Or worse, during the shutdown, did they alter legal determinations about what activities and programs could continue? And were those alterations driven by political pressure? Haphazard implementation is a problem at a time of general uncertainty, especially for stakeholders trying to anticipate and adjust to how they themselves will be affected and determine whether they are being treated fairly and consistently. It also creates difficulties for the public and members of Congress trying to understand how agencies are utilizing public funds during a shutdown. It raises serious questions about whether the administration is favoring certain constituencies when oil and gas companies are held harmless, while victims of domestic violence can't access money for transitional housing. Finally, in the midst of an ongoing shutdown, significantly changing agency plans that were supposed to have been carefully crafted with extensive input from agency lawyers raises concerns about whether the law was followed. This concern is only heightened when abiding by the law does not appear to be at the forefront of the minds of those who are managing the shutdown. In short, agency shutdown plans have a purpose. Significant changes to those plans in the middle of a funding lapse should be rare. Otherwise, such changes undermine the purpose of those plans. With that in mind, the magnitude of changes seen during this recent shutdown are even more surprising, given the context that all of the affected agencies had implemented shutdown plans over an extended multi-week period just 5 years ago, and subsequently revised plans to reflect that experience. While plans may have to change in small or unpredictable ways, there appears to be little justification for the massive changes in agency plans we saw during this shutdown. Thank you.
Thank you very much, Mr. Berger. Mr. Francis, thank you for being here, and we're anxious to hear your testimony.
Thank you, Representative McCollum, Representative Joyce, and members of the subcommittee. Thank you for the opportunity to appear before you today on behalf of the Coalition to Protect America's National Parks to share our views on the National Park Service's use of fee money during the recent federal government shutdown. I would like to summarize my written remarks and submit my remarks for the record. I am the chair of the Executive Council of the Coalition. I retired from the National Park Service in 2013 after 8 years as superintendent of the Blue Ridge Parkway and 41 years with the National Park Service. The Coalition has more than 1,600 members with more than 35,000 years of experience managing and protecting national parks. The national park has just experienced the longest shutdown in our country's history, leaving employees of the National Park Service without pay for 35 days and creating impacts to resources of the parks that were widely documented in the press. The administration took steps to mitigate any resulting bad publicity and ordered parks to remain open and accessible. The National Park Service also directed superintendents not to talk to the press and to refer inquiries to the Washington office where requests for interviews were refused. The consequences of keeping the parks open during the shutdown were confirmed in a survey that Coalition members took at 15 national park sites and at parks in the Washington, D.C. area in the last 2 weeks. I will provide a few examples and then submit our survey summary as a part of my testimony. At the Blue Ridge Parkway in Shenandoah National Park, roadways were closed due to snow and ice and downed trees. And let me just say, not just a few downed trees, thousands of downed trees. A Joshua tree was struck and killed at the Ryan Campground at Joshua Tree National Park by an out-of-bounds vehicle. At Yosemite National Park, trash, food scraps, and broken bottles were found in numerous locations, along with increased evidence of bear activity in picnic areas. A leaking diesel tank was documented at the park. Portable toilets had been vandalized, and the park dumping station was overflowing with frozen human waste on the ground. At Point Reyes National Seashore, the park was forced to close the entire Drake's Beach area where male elephant seals had come into the parking lot and threatened visitors. At Cape Cod National Seashores, public urination was observed because the park's only visitor center and restrooms were closed. Several employees were forced to seek additional employment outside the National Park Service to pay the bills, with some employees being forced to sell their belongings, turn off their hot water, or in one park, 3 young employees were facing homelessness as they could not pay their rent. As the damage to our parks became more visible, the Acting Secretary of the Interior, David Bernhardt, issued a memorandum on January 5, 2019, ordering the parks to reopen using fees collected under FLORIA. The memorandum deviated from the National Park Service Organic Act that requires that parks and their resources be preserved and enjoyed by the public, as will leave them unimpaired for the enjoyment of future generations. As each day of the shutdown proved, the resources were not left unimpaired for future generations. The memorandum also contradicted Park Service policies that say that FLORIA fees are not intended to offset the operational costs associated with a park, as well as Director's Order 22, which states that the expenditure or revenue collected under this program will provide high-quality enhancements that directly impact the visiting public. We do not believe that trash collection or restroom and road maintenance meet the language or the intent of the law and these policies. Because the Bernhardt Memorandum called for parks to use their fees until such funds have reached a zero balance, any projects that were in a pipeline through the use of these funds could now be delayed or even canceled due to a lack of sufficient funding. From the time of the enactment of the fee legislation in 2004, Congress and the National Park Service have always intended park fees to supplement appropriated funds, not to replace them. We are facing the very real possibility of another shutdown at the end of next week, and your leadership is needed to inform the administration that further damage to the parks and further harm to their dedicated federal employees will not be tolerated. We urge the committee to ask the National Park Service to account for the fee money expended by all parks during the shutdown and request a list of park projects that will be delayed or canceled because of the expenditure of fee revenues. And we also ask Congress to reimburse the fee accounts so that the list of deferred maintenance and other projects can still be achieved as originally intended under FLORIA. That concludes my statement. I will be glad to respond to any questions you may have.
Thank you. So many questions. So I think it's important sometimes, we don't want, as Mr. Joyce and I and other members, and I'm sure Ms. Pingree would conclude, we want our government to stay open. We want to get the appropriations process done in an orderly fashion. But there had been other shutdowns, and there were decisions made during that shutdown. So, Mr. Berger, given your experience of working at the Office of Management and Budget between 2010 and 2015, and you were dealing with a 16-day government shutdown, I would appreciate if you would address a couple of things from two perspectives for me. Broadly speaking, who made the determinations in 2013 regarding which agencies would remain open and which functions, if they remained open, then would they continue? Was that a centralized discussion, or was it up to each agency head? And then in respect to the Interior Department in particular and the National Park Service, can you tell us what authority Secretary Jewell had in this regard? Was she bound by a broader decision, or did she have the latitude to determine the status of the national parks? How was the decision-making done?
Sure. So ultimately, the decisions are made by each individual agency in close consultation with their general counsel, because, as has been explained so ably by the prior panelist, there's a number of laws that constrain what activities can and cannot continue during a shutdown, and that's why there really has to be that close conversation and that elaborate planning process. OMB provides advice. It also helps with applying government-wide guidance, and it ensures that there's some consistency in the ways that those legal determinations are made. For example, if Agency A is approaching it in a certain way and Agency B has a similar type program, OMB might point out to Agency A that Agency B is doing it, and so that they kind of understand how that's working. But ultimately, it's a decision made by the head of the agency, as I said, in close consultation with their general counsel's office.
So I'm going to put two questions to the two of you together later because I won't have enough time to do it right now. So I'm just going to, I'm going to be judicious with myself here right now, because I'm going to take some time at the end. So, Mr. Joyce?
I appreciate the opportunity opportunity. Thank you both for being here today. Yep, turn that on. Thank you. First, I'd like Mr. Francis. As I said in my opening statement, I agree with you that national parks should not have been open to the public without the provision of basic sanitation. We both understand the department instructed parks to use recreation fees in response to this and other basic needs. But I'm still trying to understand your argument that the use of the recreation fee funds for these purposes is contrary to the intent of Congress. In passing the Federal Lands Recreation Enhancement Act, Congress authorized the use of fees for the following variety of purposes: repair, maintenance, facility enhancement, visitor access, health, safety, interpretation, visitor information, visitor service, signs, and law enforcement. Acting Secretary David Bernhardt instructed that each park has available balances of recreation fee funds will immediately utilize such funds to address the following items in a manner that maintains restrooms and sanitation, trash collection, road maintenance, campground operations, law enforcement and emergency operations, and staffing entrances as necessary to provide critical safety information. Those instructions seem entirely consistent with the activities authorized by Congress. What part of that I've just described goes against activities that are described by Congress?
Thank you for the question. If you go back, I think, in the legislative history when fees were first enacted, it seemed clear based upon my discussions with people who were around back then, that the intent was to enhance activities, to make them better, not to pay for day-to-day standard operations. That was to be paid for with appropriated funds. And so this idea of enhancement changes what you're saying. This would be the enhancement of each one of those activities as opposed to standard day-to-day maintenance, standard day-to-day law enforcement, day-to-day operations of interpretation, and so forth. So there's just a fine difference, but it's sort of like we've got the cake that's being paid for with appropriations and icing is being paid for with fee collections.
I appreciate that, but in an emergency service circumstances, wouldn't you?
Yeah.
The authorization was
Sure,
in the best interest of the park.
That's a great question, and I've been asked that question many times now by the press. My answer is, if we were able to provide the full array of employees, that we had the eyes and ears of the maintenance staff and the interpretive staff, we had the full array of law enforcement staff to handle the huge enormity responsibility that they have when visitors enter a park. If we had that full array, then I would agree that maybe that could happen in an emergency. However, because of the restrictions, we only had a partial staff. We had way too few people. And so I've used this analogy before. It's like opening the Smithsonian Institution, and saying the restrooms are open and having a couple of people there and saying, well, go at it. If you go to the Great Smoky Mountains National Park, there's 900 miles of trail. There's 524,000 acres of land. There are 8,000 cars a day that travel on Newfound Gap Road. There's 2 million people a year that visit one other section. 2 million people visit another section. 200,000 people that go to a particular visitor center. You have to have a full array of staff there or damage is going to occur. It's just a fact.
I would agree with you, sir, but what I find most disturbing, these were American citizens for the most part doing this damage. And whether it was fully operational or not, unfortunately, some idiot thought it was a good idea to drive off the beaten track or do those things and damage our parks. So
we do have those problems. Excuse me. I just wanted to say we do have those problems when we are fully staffed, but the probability of things happening increases when we have fewer people.
So what's your opinion that Congress should amend the Federal Lands Recreation Enforcement Act to clarify which activities are and are not authorized?
Well, I think that it's been a very successful program when the public comes and they say, I'm the owner of this park. I'm the co-owner with my friend here, Sam. And we love this place, and we pay taxes to enjoy these parks. But with fees, it's this idea that users should pay more. And so we have always felt that users should get more, and that the fees and the use of those fees should relate to the uses. For example, if it's a campground, I always operated the Great Smokies or Blue Ridge Parkway, so that all the campground fees were used to improve the campgrounds. to make them better, because if people are coming to camp, you know, we want them to know that their fees are being used to assist them specifically, that it directly related to the campground operations. So I just think that, well, I'll give you another analogy, and this was a fellow that was a bush ranger, big donor, and he was on our Friends group. And he said, you know, I pay a lot of taxes. You know, if once they start substituting my donations for appropriations, I'm not going to give any more. And I think the same thing is true of fees. You know, I think people have an additional expectation if they're going to pay a fee to use something specific, that they're going to get something extra from it. Just my opinion.
I understand. I see I'm out of time. Thank you.
So let me just, the emergency that's being described with sanitation was because the parks were open, was it not? So a lot of the emergency situations that we're talking about were because the parks were left open. Mr. Berger, Mr. Francis?
Yes, and because we had inadequate staff to address what visitors were leaving behind and the kinds of activities they had been engaged in.
And
Can I, so just to
Yeah.
elaborate, I mean,
Sure.
so the Department of Interior was well aware of the risks that would come from keeping the parks open with a skeleton staff. In fact, in their plan, they told people they couldn't account for the fact that more visitors would be coming on. So when this determination was made, this is a very predictable result. When you have a bunch of people come into the parks and you don't have the adequate staff to protect them, to protect the parks, to keep up sanitation, what you have is problems with their safety, problems with the safety of the parks, problems with sanitation. This is why we ask them to do plans in the first place, so that they think about the consequences of their action and prepare for what will occur. And so I think that's one of the concerning aspects of this, that apparently there wasn't that preparation, and then later a determination was made to utilize these fees, and that also didn't appear to be considered from the outset either, even though, again, these were very predictable outcomes.
so, and kind of piggybacking a little bit on what an enhancement would be in a campground area. So you have a campground, you have a restroom facility there. It's up to date. It's not on a replacement, but you as the camp person and the park superintendent are hearing, you know, we really need another changing table. Or, you know, we like the fact that there's water available. Can you help us with the drinking fountains, put something on the outside to help us fill our water bottles? So those become enhancements to something that already exists. But once those fee monies are spent for regular operation, then that enhancement that the visitor at the park has requested, that the staff has identified, then now those enhancements can't happen because the fees are gone. Is that kind of a correct
Yes,
example of?
That's correct. There's a long list. There's a chart that's in the Green Book, our budget book for FY19. There's a great chart that lists pages of projects that now there is no money to fund. And those are needs, real needs, and they are now going to be added to the deferred maintenance backlog. You know, instead of it being 12.6 million, maybe $1 billion, it's going to be, or 11.6, whatever the number is. It seems to change every day. 11.6 billion, 11.7 billion. This is going to have an impact on that deferred maintenance.
So just to kind of clarify, you know, so if I say that the fees are going to be used towards maintenance, it's maintenance enhancement.
That's correct.
Not day-to-day
That's correct.
maintenance. And then the backlog is, as you pointed out. So, Mr. Berger, the first panel, GAO, talked about the appropriations law, that once an agency picks an appropriation to charge for an expenditure, it must stay with that source.
Mm-hmm.
So in your opinion, this recent shutdown, did the administration, in your opinion, did the administration violate pick and stick principle when they diverted recreational user fees to pay for park services?
Well, I think it raises, you know, very serious concerns, very serious legal concerns, for this very reason. And partially part of the problem is we don't know exactly what the funds were being used for. I mean, we have sort of a general description, but because it wasn't included in the plan, I think there was a brief letter, a few press reports. It's not even clear exactly the extent to what these funds were used for. And again, this is why they engage in the planning process in the first place. But certainly a situation in which you have ongoing appropriations that you all provide, and then the separate set of fees for enhancement, when you then basically utilize those fees for routine operations, it raises these kinds of serious legal questions, and I think it requires, further inquiry, both an inquiry really that the agency should have been conducting prior to taking any such action, but also, by this body to determine exactly what was going on and whether or not the law was being followed.
And I agree with Mr. Joyce. For example, the barriers that were put up around the World War II memorial were they were not appropriate in my opinion. It was a bad idea. So, you learn from a shutdown plan, and then maybe that's something that you don't do again. But in 2013, when you were at OMB, was there any discussion, because these user fees were available then too, was there any discussion to use user fees to transfer them over to pay for park operations at all?
Well, the determination was made by the Department of Interior in 2013 to close the parks because keeping them open with a skeleton staff would pose a risk to the parks themselves, to the visitors, as well as create, health and safety sort of risks. And so it wasn't a question of sort of, we're going to keep these parks open with a skeleton staff, what do we do next? But rather, we're not legally able to keep on sufficient staff, and so the thing that's best from the perspective of the program and consistent with the law is to close the parks down until Congress provides appropriation.
Thank you. Mr. Joyce, I'm going to go to Ms. Pingree.
Oh, please.
Well, first, thank you both for your testimony, the work that you do. Really appreciate you bringing your expertise back from the previous administration, and thank you so much. We value our national parks and really appreciate all the work that you and the organization do, so thank you. And I'll reiterate a little bit of what we've already been talking about. I'm lucky enough to come from the state of Maine, and Acadia, of course, is one of the most visited parks, and then we have our new national monument, which we're really excited about. And it was somewhat fortunate for us. This happened in the middle of the winter. Our busy season isn't the winter, although there are activities around skiing and snowmobiling and things that happen in the winter. But it wasn't quite as stressful as it was for many of the other parks that had these high rates of visitors. But certainly all of the things that you've already discussed are huge challenges and are concerns about how these user fees were used. And the importance of having them available for all of the things you've already discussed. Another concern that was raised in our discussions with personnel at our national parks, just trying to understand how this impacted them, were really some of the behind-the-scenes projects. I mean, we have an incredibly busy, short season, and then we have the winter to catch up and get everything done. So, transportation improvements, delayed winter contracting, deferred maintenance, all those things that are extreme that have to happen in the winter, as well as just the planning process. We're trying to deal with high levels of transportation needed in the park, and some of the planning going on around that just doesn't take place. And as we thought about it, 35 days is really 10% of the year, and an even greater percent of the time that they're not stressed and busy with all the visitors is extremely important. So I'm kind of interested, just as a follow-up to what you've already been talking about, to hear a little bit about that kind of stress to the parks. This is this is time they can't get back, and there's a lot of work that happens that we don't think about that goes on behind the scenes. And then just another part of this is some of what you've already talked about, but this whole decision that was made that employees would be furloughed, but then they weren't, and kind of this midstream adjustment that from the outside seems political and seems arbitrary, and in some cases, as you've kind of described to us, not legal. But can we just talk about those two areas generally, and you're both knowledgeable about both?
Sure. It seemed political. It certainly did. It seemed that it was the reopening of the parks was a consequence of some pushback from the American public.
Mm-hmm.
I understand that. I probably would have done some, tried to figure that out myself if I'd been sitting in their chairs. In fact, in the 2013 shutdown, while we did close all the parks, you may recall that a number of concession operations said, you know, we want to stay open, and we allow them to. And that is different than what happened in 1996 during that shutdown, where we were closed for about 3 weeks. And in 1996, we put barricades up on the roads, and people could not go into the parks. And I really understand that, and sort of back to our discussion before, if you don't have the full complement of staff, in our view, you're really violating the Organic Act of the National Park Service, you know, to leave the parks unimpaired for future generations. And then there's the Redwoods Act. It says that managers will do nothing in derogation of park values. And so by not having the full staff, it's virtually impossible to protect the parks, to cover such an area. And the consequences of this shutdown will be felt in the months to come.
I've got some I'm using.
We did not have personnel working in Washington in our regional offices in the personnel division, rating and ranking applications for seasonal employment for the busy season in parks like Acadia. That means that people who have applied may not hear back from their applications. They may actually go find another job. They may not be available any longer to come work in the national parks. Seasonals are really the backbone of park operations, you know, in the visitor season. It's really important to us, to the Park Service,
That's a very good point.
that we have these talented young people, usually young people, who are really dedicated and committed to the mission of the service and providing outstanding visitor service so that people will keep coming back. So there's going to be a delay in the hiring of seasonals. Now, what does that mean? That means that spring cleaning, as we do in the Blue Ridge Parkway and the Great Smokies, is going to be delayed because we won't have the staff necessary to do that spring cleaning. That means that campgrounds may be delayed, may not be opening. Tourism companies who want to come to Yosemite and they print their brochures in advance and they say, come take our tour, we're going to go to Yosemite the first week of May. You know, are they going to be able to or not now? We're not so sure. It affects state employment tourism offices who are working with other countries, tourism from other places, to bring people here and go into the parks. Will the facilities be open? We're not sure. It may be delayed. Last year was a bad year. It took a long time. The consolidation of personnel into a stovepipe operation for interior cost part of this, but now with the shutdown, it's going to make the delays even longer. So I could go on and on and on.
That's great.
And it's all, so I want, Ms. Pingree, do you want Mr. Berger to take a minute?
Just a second about the, you know, sort of decision midstream, and you've talked about that a little bit, but that just seems hard to understand the legal
Sure, and just,
ramifications.
if I may, with respect to the chair's previous question about pick and stick, I neglected to mention that at least reportedly, the Department of the Interior is looking back to see whether or not they should be shifting these funds from park fees to operational. There's apparently an email sent out internally that was then reported on, and so apparently they too have some open questions as to whether it was legal. But with respect to your question, I mean, this is an unusual thing to see, and one of the things that OMB sets out guidelines for how shutdown plans should be designed, and one of the things that OMB explicitly says, I didn't say we that time because you made the same mistake, but OMB says, is that you're supposed to plan for a short shutdown and then a long shutdown, right? And the notion here is you're supposed to think through. That's why these take time to do. You're supposed to think through how this happens over time. And to see all these circumstances, even in the case in which money may be available and could be used for these purposes, you would then put that into your plan. So, for example, there are agencies that operate on carryover funds for a period of time. The EPA was an example of one. And so you set that forth. But when you make the determination midstream, that raises serious questions. Either you didn't plan properly, as you were supposed to, or you looked at it, decided you couldn't, and then changed your mind in the middle. And that's what I think is really concerning, and that's why at least when I was in the administration, we told agencies to take these plans very seriously. I would also just say these plans are made public so that people can review them, so that stakeholders, members of Congress, and the public can understand how agencies are going to be utilizing public funds during a shutdown.
Thank you. Thanks, Mr. Chair.
Mr. Serrano, welcome back to the committee.
Thank you.
We're
I'm
happy
glad
to
be back
see
in the
you.
committee. And congratulations to you for on your chairmanship. We've served together on many committees for many years, and I have the utmost respect for you.
Oh,
It's nice to call you Madam Cardinal. Thank you so much. And thank you for joining us today and giving us this information. I think this is an issue that most people don't touch on. You know, shutdowns take place, unfortunately more than they used to when I first came to Congress. And people sort of live with it, deal with it, and then no questions are asked later. So I think, Madam Chair, that you've done something really good here in having this hearing, because it allows us to ask questions. Mr. Berger, in your experience at OMB and having lived through the 2013 shutdown, can you give us a sense of the standard protocol federal agencies and departments are required to provide employees in terms of communicating information about what to expect in the lead up to a shutdown, during a shutdown, and after funding is restored? And how quickly are federal employees expected to receive back pay once a shutdown ends and Congress authorizes it?
Yeah. So with respect to the first question, agencies in their plans are supposed to both talk about how they're going to do the shutdown itself, how things are going to operate during the pendency of the shutdown, and then how they're actually going to bring people back, which you can imagine is actually a little bit challenging because when folks are furloughed, they're not allowed to be checking their emails. You don't show up every day at the office and check to see if, the lights are still off. And so it is actually a challenging thing for agencies to figure out how to make those communications. So there's a lot of time and effort that agencies put into that, as well as agencies in their planning walk through who's going to tell everybody, right? So, the Department of the Interior, National Parks, and these are big places with lots of people. And so, someone writes down something on a sheet somewhere that says the following 5 people are going to be furloughed. Well, someone has to make sure those 5 people know, and these 5 people know, and these 5 people know. So there's a tremendous amount of work that agencies put in to making sure that they're communicating with employees before, to a certain extent during, although that has to be very limited, and then after. The during part would be for employees that would be anticipated to come back on. Again, this is why that planning on the front end is so important. So emergency responders, for example, are maybe alerted that to the extent that, say, you don't need the full complement, that they may be called back at some time so that they can be aware of it. But for example, in a circumstance like this in which you may have had significant staff that understood themselves to be furloughed at the beginning, it then is complicated as to how you would communicate with them that now the agency has shifted course, and in fact they aren't going to be furloughed and are going to be brought back on. That's one of the reasons why agencies are supposed to plan ahead of time and figure out who's going to be kept on and who's not just initially, but over the course of a longer shutdown.
Now, in this recent shutdown, was this a serious problem? Did it create, people were not aware? I had no idea that you couldn't find a way to check on the messages coming into you.
It's a challenging circumstance. I'm not personally aware of whether or not individuals had problems with this, but it was something that we had to deal with because, in essence, if you tell people they got to be checking their BlackBerry every 10 minutes, then they're working, right? That's what they're doing, even if they check it 10 minutes and.
Well, if they have a BlackBerry, I think we have another issue, right?
Well, this actually, you do raise you raise an interesting question. Some agencies did, in fact, collect BlackBerries, but one of the concerns, one of the problems in implementing a shutdown is, that these folks are really mission-driven. They care about the work that they're doing, and telling them to stop, to basically stand down, whether it be at the parks, whether it be at any of the other agencies, EPA and the like, is very challenging. And so people had to be very clear, you can't do your work. I know that you are doing this because you think, and you know that what it is incredibly important to the American people, that you serve an incredibly important function, but right now, you can't do it. And it was challenging to make sure people understood that. And they didn't try and show up and just get 2 more things done, because this is going to mean so much to these people if I can just get this paper out the door. You had to say no. And this is sort of the problem with the shutdown. Shutdowns are bad for business no matter what business you're in. And it means that a lot of really important things stop. And that's why I think, as the member so correctly pointed out, We shouldn't have them in the first place.
Madam Chair, do I have any time left? No. Oh,
If you've got a quick question, we'll do another minute.
I just wanted Mr. Francis to tell us if the members of your coalition feel that the administration gave them sufficient information and communication from leadership on what to expect before, during, and after a shutdown occurs. Have your members currently employed by NPS received all of their compensation for the duration of the shutdown, and have all parks become fully operational?
Now, our coalition is comprised of retired National Park Service employees. So we have about 1,600 retired employees, and we have some active employees. With regard to communication of current National Park Service employees, I think many people felt that they were in the dark, that they did not receive communication. And communication is hard because people work 7 days a week, multiple shifts. It's not easy to always communicate with all of our employees, but I think that that's certainly an area that could be worked on.
Thank you. Thank you, Madam Chair.
Mr. Joyce, we are really fortunate on this committee because we've added Mr. Serrano from New York, a Great Lakes state, and Ms. Lawrence from Michigan, a Great Lakes state. And welcome to the committee.
Thank you.
And please, if you have a question.
Yes, I do. And thank you, Madam Chair, for having this discussion. You know, in the testimony, it was mentioned the harm shutdowns cause to ongoing research and data collection. The longest running study of predator-prey relationships in the world, it was 50 years, occurs on Isle Royale, the national park in Michigan. Unfortunately, researchers were not allowed or permitted to access the park during the shutdown. So here we are, have a 50-year-old study, and this was a critical time for researchers who needed access to track the animal movement. I'm concerned about the study being compromised and valuable data being lost. What's the consequences of suspending research studies during shutdowns?
Well, you're exactly right, and it happens not only at Isle Royale, but other parks around the country, Yosemite, Great Smoky, Shenandoah, Everglades. But to have a continuum of data so that you can examine whether or not these data points are within the norm. I mean, you might be measuring things like, I think at Isle Royale, the air quality is a big example. Mercury deposition is important. It's important that they have that continuous record throughout time, and gaps don't help. It may not necessarily destroy the study, but it does produce gaps. In the Great Smoky Mountains, the first scientists, I think, arrived in the early 70s, and they too have a continuous record of air quality, water quality, and so once again, those gaps.
But why were research staff denied access during the
They
shutdown?
didn't meet the definition of essential employees, and by the way, if this committee could ever change the names of essential and not essential, it doesn't feel good when someone says, well, you're not essential. You know, well, you might have saved someone's life yesterday, but you're not essential. Is too bad.
And
that's
it's because
just
of their
That's right.
title.
The restrictions and the plan are pretty specific about the types of employees that are essential and the types of employees that are not essential. And scientists and resource management people are considered not essential.
May I have one more question?
Please.
Okay. As a former park ranger and superintendent, can you talk about, and you have, the long-term impact? But one of the things that I'm concerned about is the repurposing user fees in the future of, because right now we're in a mode in our government where threats of future shutdowns. So if user fees are depleted, potential concerns for visitor safety, because this whole fee structure that we know we need to operate, and if we continue to use shutdown as a mode of political operation, if we deplete these fees, what is the long-term impact?
Well, thank you for that question. You know, we have bigger parks that have a lot of fees, and they can accomplish bigger projects. They get to retain 80% of their fees. 20% goes into a little pot that the small parks who don't collect fees compete for. And sometimes there's not enough money to actually accomplish a project. They save it up. And I know that's been a subject of this committee's discussion in the past. And questions have been asked about unobligated balances in these fee accounts if we have such a need. But there's not enough money, so they sort of collect these, they bank these funds so that they can have enough money to accomplish a deferred maintenance project. Well, so let's say that they try to bank them for a couple years or 3 years. All of that money is, I don't know how much of that money is gone. It'd be interesting to see. But much of that money is probably now gone, which means the parks are going to be waiting even longer to accomplish these projects. Great example about campground restrooms, campground sites are two good examples of wayside signs, interpretive signs that enhance the visitor experience, provide orientation information to people about how they're supposed to use parks, what happens if there's an emergency, you know, who do you call, how do you reach people? You know, all of those kinds of projects will be delayed.
My next question, and Madam Chair, I will ask this because will there be a financial impact report submitted to this committee that actually outlines how much money was lost and the impact that will have on those projected projects? Will we get that?
Yes, we're going to be requesting that.
Okay.
So we've got the deferred maintenance we need to find out about. We need to find out what projects will not be able to take place because of what happened with the fees. But then we're also going to have to get a handle on all the damage that was done. So we have our deferred maintenance. We have new damage done to the parks, which is going to contribute to more of that. And now we've depleted the enhancement fees that have been collected. And so that is something that we're going to get, and we'll take a real hard look at it. And that's why we also have to ask GAO the questions that we did to find out if something improper happened, how do we keep it from happening again in the future? So, Mr. Joyce, I think I've got one more. Yeah, my folks came in at the end. You had the early birds.
Thank you, Mr. Berger. In your opening statement, I believe you talked about BLM continuing with the energy permitting during the shutdown. You heard my conversation, I know you were here for it, a conversation before with Ms. Matta about continuing appropriations. Were you aware the BLM was under a continuing appropriation at the time?
So again, the issue there is, with respect to BLM, is not around the legality, or at least I was not raising questions about the legality. It's about the planning process, right? So making a change in the middle of a shutdown raises these sorts of questions. If the funds are available, as you're saying, did they decide beforehand that they were going to use them, that they weren't going to use them? And if they didn't do that, well, what changed in the middle, right? Because they're supposed to be planning under OMB Circular A11. They're supposed to be planning for a duration. And the exact reason why is because it raises these sorts of concerns. You make a change in the middle, and suddenly everyone's saying, well, what's different? You know, what are the new factors? And that's why we ask, or excuse me, OMB asks agencies to make these plans and then publish them.
Sure, fair enough. And so you were part of the senior team in 2013 that you put together this draft OMB thing for guidance for the agencies?
Sorry, do you mean the government-wide guidance that agency provided?
Yes.
Yes, I was part of the team at OMB that.
You said the senior team. Was that run through the GAO? For them
Was OMB's guidance run through GAO?
To have them? Okay. So this was just the guidance of the legal team within the OMB at that time?
Well, this was, yeah, I mean, this was OMB guidance that obviously,
With OMB's legal counsel being you and others. Fair enough. So in the, what you just cited before, if BLM, well, let's go back to this. That shutdown went down, if I remember correctly, 17 days, 16 days?
16 days, I
Okay.
believe.
Seemed like eternity when we're stuck.
It did seem like a long time.
You know, after 5 days, were you getting questions from some of these agencies as to, you know, we had a 5-day plan and it looks like we're going on to a 15-day or longer problem. Did you have questions from agencies as to how to make changes in the game plan?
In certain circumstances, you know, various agencies would raise discrete issues on which they were trying to figure out what to do. Yes, I mean, obviously the government is a big place, and so you can imagine. A lot of that, though, would come up with sort of unexpected activities. And so, for example,
Well, certainly you made a change when the World War II vets showed up there and you took down all the barricades and all the signs. That was done 5 days into it, 6 days?
the Department of the Interior did make a determination that because those sites were open for First Amendment-related activities, that in fact individuals should be allowed to access it. But that is a good example, and
But the Interior, with their counsel, made the decision to go ahead and maybe ran it by you?
well, again, they don't run anything by us in the sense of us providing approval, but certainly to the extent that there are questions that are raised or they want to seek OMB's guidance, they do.
So the agency then can talk to their counsel, make decisions on the fly, 5, 10 days as the shutdown continues to extend. They can make those decisions on their own, similar to what BLM did in this circumstance.
In response to unexpected circumstances, you know, agencies, you know, basically when your plan first comes in contact with reality, you can imagine that there are going to be changes that were made. I think what's particularly interesting in this set of circumstances is, you know, everyone lived through a long shutdown, as you said, 16 days. So, and many of the, while obviously the political staff has changed, it's a new administration, the career staff are, many of them are the same people, right? And so they were there before, they saw what happened, and they understood. So it's not as if it's a surprise to anyone there that these sorts of activities were occurring or that would need to occur. It's not a surprise to anyone that over the duration of a shutdown it would become, you know, more problematic. And then again, that then raises the question about why the change in the middle and whether or not people were doing the proper planning. And I think it should be concerning to folks because
Well, if they did all the proper planning, but they have new council, new administration, new council, new secretaries, and they make those decisions, just because they made them doesn't say that they're wrong or correct, or wrong or right. I mean, they made those decisions based on the information they had in front of them, and that's different than 2013.
So again, just separating, just two different types of things. There's different legal determinations made on the front end, or and sometimes programmatic determinations because there may be two legally available options. And then there's a circumstance in which you've made a choice at the beginning, and then halfway through the shutdown, you yourself change that choice. And that's what I'm saying raises particular concerns because agencies are supposed to plan for those circumstances. They're supposed to think through what it is that they're doing. And so then when they make that change, the natural question to ask is, well, what happened? Why did you make that change?
But the difference too is that in 13, it was a complete shutdown. All the agencies were shut down, and here you had, for lack of a better term, cherry-picked departments that their appropriations weren't approved. So you have a difference in between only 24%, I believe, of the government was actually being shut down. So that's a different way that they'd have to look at how they're going to go forward.
Well, so for the agencies that are themselves impacted, it's largely the same, except to the extent that they're working very closely with another funded agency. And the standard there would be if their activities are necessary, so if they don't undertake those activities, if it would significantly damage or even prevent a fully funded function at another agency, then they would have to, then that activity might have to continue again. In that case, agencies would engage in that planning prior so that they understood what was going on. But to the extent that you're talking about responsibilities that are solely within a particular agency or don't involve a fully funded agency, from that perspective, the 2013 shutdown and the most recent shutdown would actually look the same. Sorry, just one other. There would be, of course, differences potentially with availability of carryover balances, meaning, you know, perhaps you have $1 million one year, $500,000 the next, and so, you know, there are those kinds of particulars, but the determination to use funds would be the same.
But the interaction between the executive and Congress would be such that we pass a law, the executive is going to determine it, in this case be OMB or other one. And if there's a conflict, then it's resolved in the courts, and the judiciary comes in and makes a final determination. Is that correct?
You mean if there's a dispute
When the
between
laws are in
Congress and the executive branches?
Correct.
Well, I mean, so one of the first things that happens is the agency itself is supposed to look into any sorts of circumstances, determine if there's an ADA violation. GAO can look at it, the Inspector General, but ultimately.
But the end result will be in the judiciary, correct?
Generally speaking, these sorts of appropriations issues don't reach the courts frequently because there isn't sort of a plaintiff that brings suit, but you could imagine a set of circumstances in which eventually a court case would be brought.
But that's what occurred in certain areas of the Affordable Care Act, correct? That went to court, it was litigated in the federal court system?
Certainly there are, as I said, there are circumstances, but for the types of ADA violations that, routinely come up, those are usually handled within the context of the agency. And then, a report is sent up to Congress, a report is sent up to the president, and then the agency sets forth the steps it's going to take with respect to the individual. And I think, the prior panelists, as she ably set forth, there's a range of options that the agency can take.
But whether or not something was appropriately appropriated is a matter for the courts to decide in the final conflict.
Yeah, I mean, ultimately, if there's a legal question about the interpretation of a statute, as with any other, whether it be an appropriation statute or another statute, that would be a determination that would be reached by courts. Yes.
Right. I have no further questions. Thank you.
Thank you. I think before it gets to the court, maybe a side can say, on further reflection, we shouldn't have done it this way, and avoid the courts altogether and the taxpayers a lot of money, time, and angst.
Yeah, you were kind enough to provide us with the definitions. I'm sorry.
I know you were.
Going here when I start talking.
And your background in following the money is also going to be very helpful in this committee. I wanted to just on the BLM issue with the leases in particular moving forward. Not only I think that if they had carryover funds, and what they did appears to be legal, was great, but then they kind of picked and chose which leases they were going to work on. So oil and gas moved forward, but alternative energy stalled out. So I think that just goes to showing that the planning wasn't what it should have been. So I think there's questions that have kind of arisen more on that rather than whether or not the funds could have been appropriated. It's like if funds could have been appropriated, all the funds should have been used for that. I wanted to just kind of go back on the fees again, just for a second. But before I do that, I think you would agree with me, Mr. Joyce, that we want to avoid shutdowns. We also want to avoid the pain and anguish that our federal employees, their families, our contractors, their families, and as we're talking about national parks today, our concessionaires and their families went through. It was a lot of stress, and in my opinion, and I think appropriators, we often say if left to our own, we can get the job done, but when the politics interjected, everything came to a halt. So I'm going to talk about employee morale and employees for a second, but I didn't want this hearing to go, and I think with both of our thoughts that we really regret what happened to their families, and in many cases, hardships that will have ripple effects for years to come. So I would like maybe you to elaborate a little more about employee morale, but one of the things that Ms. Pingree and others touched on with the fees is Secretary Bernhardt's words kind of struck a nerve with me when he said, until they reach the fees, a zero balance. Because I learned something. I learned something new every day, and a couple of weeks ago I learned that the FLIFR fees are also used to hire staff as needed to collect the future fees. So if a park was forced to use all of the fees during the shutdown, who's going to be there to collect the fees once the park opens up again? So going to a zero balance was not, in my opinion, a good idea. I don't think it was a good idea to use the funds in the first place, but then to take them all the way down to zero. And then I understand that many of the maintenance employees that are hired for the park season and then are rehired for additional months, they also use the fees to address backlog projects. So the loss of these fees are likely to affect us to be able to retain those employees to do the needed maintenance work. So how is this, and not to put you on the spot, but what are some of the concerns, what are some of the things Mr. Joyce and I should be looking at with the employees and getting things done and employee morale that will impact as we move forward.
I think that with regard to morale has been on the decline for some time now. It used to be that the National Park Service was always rated as one of the best places to work in all of government. And unfortunately, that is no longer true. And I think that's a consequence of a lot of things that have happened. The buying power of our budgets continue to go down. The standards of work that people were accustomed to have therefore declined. I've had people come into my office visibly upset, emotionally distraught, because they could no longer maintain the parks at the same level they've been able to and throughout their career. At a time when people are reaching retirement age, to see their units, like a historic preservation crew, completely disappear has had a tremendous impact on our staff. I think the last average age number I saw was 56 years old for the National Park Service. Are reaching the end. The institutional memory is going out the door. We're unable to hire new employees because of budget restrictions, reorganization, and so forth. The reorganization that took place in the 90s, where we lost some 1,500 permanent employees in 3 regional offices, eliminated a lot of support for the small parks in the field. They no longer had access to engineering services and so forth. There's many different components. But then now, after people were giving more and more of their lives and effort to trying to keep these parks up to standard for the American people, to be sent home for 35 days is devastating. It's devastating. Shouldn't happen again. And so you're right, that with the money being spent, that means projects aren't going to be done. That means that people may not be hired. We hire temporary employees and permanent employees. Many of these projects are done with temporary employees. If that money doesn't exist, they won't be hired. I don't know what we're going to do about the Park Service is going to do with regard to collecting fees. If there are no fees to pay for fee collection, I'm not so sure what's going to happen there. We've never faced that situation. I've never faced it in 41 years. So I'm not sure what will happen.
Thank you. Well, anything you wanted to add?
That covered it well.
I want to thank you both for your prior service, working for the federal government along with all of our federal employees, and for your active engagement in making sure that our parks and our government work to serve all the people. And thank you so much for your testimony today. Mr. Joyce, I inquired about the NPCA testimony and whether or not you had any objections. Have you had a chance to thoroughly review it since we've been sitting here?
I have not, but I'd be happy to agree to those if we could also include for the record the Department of Interior, allowing them to respond as well.
Oh, absolutely.
Okay.
That's good.
Thank you very much.
See? Already off to a great start. So as I said, I'd like to thank all of our witnesses this morning. After a lot of research that I've undertaken and listening to the testimony, I've decided that I will be making a formal request for the GAO to provide legal opinion of the Department of Interior's use of recreation fees and shutdown. And we'll also confer with other members of the committee if there's follow-up things that they would like to submit or add. I mean, people are welcome to do that as members of this committee on their own, but if we want to enhance what I've got ready, we can work on that together. So today, I'm more than convinced, sadly, that the administration has ignored the law and the policies that the agencies have had in place for years to protect our citizens and our public lands. I believe the decision was made to open up the parks to mitigate the impacts of the Trump shutdown. And I fear that the administration is willfully ignoring the counsel of dedicated men and women who work every day in our parks. They had found their jobs put into effect to create policies to suit other people's politics. So I'm committed to working with all of my colleagues to protect our constitutional authority with oversight. So I'd like to ask members and staff to submit any questions that they'd like to have by the end of the week. And with that, Mr. Joyce, I'm going to adjourn the meeting. Meeting adjourned.
Thank you.